Thank you for joining us. We are going to go ahead and get started. It's a minute past 6 o'clock. So really want to thank you all for joining us this evening. This is the second of a three-part series that we are providing to our members regarding some upcoming proposed legislation leading into the legislative session. Tonight's focus will be on judiciary and final decree transition. I have with me Clayton Elliott with Trout Unlimited. He is a member also of the DNRC Comprehensive Water Review, and we have been working really closely together on this legislation. Clayton also was one of the primary bill drafters for this legislation, so he's going to be the technical expert and take a deep dive into some of the bill parts and pieces as we get started. So before we start those details, we're going to go ahead and jump into just some quick overview items of a final decree transition. Like I mentioned, this is part of the comprehensive water review process. Final decree transition is really trying to address what we do with statewide water adjudication for the long term and how it's administered and how your water rights are handled. I wanted to quickly just highlight a couple of things. So we're looking at adjudication right now with the water court or the adjudication court that is in Bozeman, that is pre-1973. And then we have the part of new appropriations that have happened since 1973. And those water rights are currently just provisional water rights. So what this component and these two bills that we'll be talking about this evening are trying to do is kind of finalize the map forward on how water will be administered. And also the goal of with the new appropriations is how do we take those provisional permits, get them through the process so they can get their certificates of water, and there'll be like some finality with that process as well. Before I kind of hit on this slide, I did want to kind of just address the question that we probably receive the most, and that is Senate Bill 72. Many of you are probably familiar with that bill. That was a bill that was introduced in last legislative session. This year, I would share that the approach has kind of hit, or we've approached it in a different way. So Senate Bill 72 really was a very big bill that had a lot of parts and pieces to it last legislative session and was unsuccessful in getting through the legislative process. As we approach this issue this year in this interim, we really did kind of put Senate Bill 72 on the shelf and really looked to break it into three distinct pieces that we would create legislation for. So the three pieces include the judiciary and what we do with the judiciary, the provisional permits component, and then there was the day-to-day component related to water commissioners. WIPIC, the Water Policy Interim Committee, kind of tackled that water commissioner portion, and at the end of the day opted not to move forward with any proposed legislation. So that's where it leads us with the two that we'll be talking about tonight, the judiciary and the provisional permits. So let's dive a little bit into the courts and water administration and where we're at with that. And before I do that, I should also give a friendly reminder that we are recording this seminar and we'll have that available for you to go back to. Also, we would encourage you, if you have any questions this evening, to drop those in the chat and we will get through those questions as we work through this. So really what we're trying to do with the adjudication or judiciary bill is to define the court and who hears water rights issues. We're looking right now, there are multiple different avenues depending on the type of water issue that you have that you could go to. So what this bill is trying to do is create a one court to address all water issues, clearly define roles and responsibilities, create a timely, accountable, and efficient system for water decisions, as I mentioned, like address those multi-jurisdictional water conflicts and ensure that local knowledge and control is still in place when doing this. So we have multiple places where water is being heard right now. You can hear it. Cases can go to the district court. There's some divisional court options, and then there's adjudication court. So what we'll be presenting tonight is trying to address and streamline and make a more timely and efficient scenario for all water users. For those of you who may not be as familiar with how this current statute is set up, within the statute, there are 4 division courts for water issues. Those are listed right here on the map. They are different colors. And really, if you look at final decrees, those division courts are the ones listed on water rights. So what this bill will do is maintain those existing division courts for water issues. Clayton, I'm going to hand it over to you and you can kind of dive into the nitty-gritty on the judiciary bill.
Well, thank you, Rayleigh, and it's good to be with you guys tonight. I appreciate the opportunity, and certainly an important topic. And to sort of set it in context, I have appreciated working with Rayleigh as well as Abby Brown, a water rights attorney.
I can't hear you, Clayton.
Ah, can you hear me now?
I can hear Clayton just fine.
Kenny, can we do a sound check? Can you hear him?
Yeah, I can hear him just fine. Can you hear me?
Perfect. Now I can. I'm good. Oh, it looks like he just hopped off. So sorry about that, guys.
When in doubt, just join again.
There we go. It might have been a technical issue on my end, Clayton, so thanks for that.
Yeah, so you can hear me now. Fine.
Yep.
Great. Well, I apologize for that technical issue. All you missed was me saying thank you for the opportunity to be here. It's great to talk a little bit more about the judiciary bill, and appreciate the work that we get to do together on complex water issues. As Rayleigh mentioned, myself, Abby Brown, a private water rights attorney in Helena, Ryan McLean, also a private water rights attorney in Helena. Many of you are probably familiar with those two. We're sort of the core team drafting this judiciary bill. And I wanted to, before I dive into the work and sort of the product of compromises, also sort of set the stage a little bit of why I think this bill is important and what brings all of us, no matter if you are irrigated agriculture person, stock grower, person who does water right issues related to fisheries, municipality, why this matters. Because for all of us who interact with pre-1973 water rights, either through the changes and or integration with new permits, but also the administration of those water rights, I think this is critically important. And a couple pieces I want to highlight before I dig into what we have drafted and are proposing to the next legislature. I think it's important to sort of start back at that first slide where Rayleigh talked about the adjudication process. And what I want to highlight here is in the understanding of what we're doing today with this proposal really is reliant on the understanding of adjudication. So that pre-1973, the sort of legal due process procedure in which we are quantifying all of those existing water rights across the landscape. When you're thinking about adjudication, there's sort of 2 steps. One is the adjudication, the actual sort of quantifying through a process that provides due process protections for all parties. That's the adjudication activity. And everywhere across the West, what comes next is the administration of those final decrees. And that's what we're talking about, is this transition from a period of adjudicating and quantifying to administering the sort of final quantification that is embodied in a final decree. And one piece that's, I think, important in setting the historical context, back in the 80s, the legislature commissioned an independent study called the Ross Report to do a deep dive third-party analysis of the legality and constitutionality, and basically just that how are we doing with the adjudication process and the laws that we set up in the state of Montana. And by nearly every account through the Ross Report, we passed the bar, and the finding was that we were certainly doing a great job, and many states would say we're one of the sort of the envy of the West in terms of the adjudication procedure. But the Ross Report did highlight that while Montana had built out a well-established adjudication process, Montana, and this is a direct quote, Montana has not yet provided a modern, comprehensive, and permanent water right administration scheme through a bureaucracy of state water administration officials as some other appropriation doctrine jurisdictions have done. So while Montana did a lot of great work in setting up an adjudication process, understandably, I think the legislature said, well, let's do this first task of adjudication first. And whenever we get to the administration of those final decrees, we'll figure out what to do next. And so that sort of sets the stage for where we're at, as we now have, I believe, 9 final decrees already entered. And talking with Judge Brown and Judge McLeay, you're expecting maybe in another 10 to 12 in the next year. So that's what's timely about this, is that we are hitting that point. It feels like we've been through the adjudication forever, and it has moved very slow, but or not fast enough for any of us. But we are getting to that point where the end is in sight. So it's timely, and I think urgent, to begin this conversation about the administration component of those pre-1973 rights that are quantified in final decree, which leads us to this bill. And I just highlight on the next slide too, one of the sort of, I think Rayleigh did a tremendous job in highlighting what we set out as our goals in imagining what this comprehensive and permanent water right administration scheme would look like. These are the goals, but part of that was rooted in the problem, because the legislature has not comprehensively thought about what comes next after the adjudication process. The current statute is, quite frankly, a mess, where many aspects of the administration of a water right are handled by different courts, and you'll see those courts at the bottom. The district courts, the current water division courts that are in statute, the adjudication court, which is what we all know of as the water court in Bozeman. Any given water right dispute or challenge that you have in administering your decreed water right, you might have multiple elements of the dispute that land in each one of these buckets or types of courts. So it creates a very complex, challenging situation for a water right user, whatever sort of type of user you are, whether you're like me on working on fish and wildlife beneficial use issues, or stock water issues, or irrigated or municipal. If you're trying to administer your water right, you might have to go to multiple courts to resolve one issue. And that's something that really doesn't make sense. And the product of that is just that the legislature really hasn't comprehensively considered what should come after the adjudication. So Rayleigh was exactly right. One goal was to establish one court, so that if you have an issue related to your water right, you have a one-stop shop where you can resolve all of the elements of that dispute or question in one place, and you don't have to pay attorneys to represent you in a district court for one component of that issue, and in a division court for another, and then at the end go back to the water court or the adjudication court in Bozeman for yet another element. Which, as you navigate those multiple jurisdictions, you're also not being timely, and you're certainly not being efficient in making judicial water decisions. So I think those are really important, and Rayleigh covered those. The last one I just highlight would be the multi-jurisdictional conflicts. I think one issue that we're recognizing in the administration of water rights, through the adjudication process, we really had to neck down the quantification the legal procedures for quantification into a place that was doable and manageable, and that those are the basins that we know of through the adjudication process. But we certainly all know that water flows across those boundaries, and as we get to the complex administration of decrees, recognizing that many of those are going to span jurisdictional boundaries, particularly the jurisdictional boundaries that are not based on any hydrogeography or hydrology. So the district courts in particular that Montana had created were not tremendously efficient because you might have a dispute that ends up into two different jurisdictions. I sit here and I live in Butte, and I can very much imagine living on Silverbow Creek and having a dispute that both would be an element between me and my neighbor lives in Deer Lodge County, and I live in Silverbow County, which is two different judicial districts. So who has jurisdiction? So I appreciate kind of going back and setting up the context of why I think this is an urgent issue, and why the comprehensive review has spent two interims going through this. And Rayleigh did a great job talking about the last interim landed on Senate Bill 72, and we felt that it was useful to take a step back at the beginning of this process, look at what made that bill more complex maybe than it was necessary or confusing, and tried to focus our discussion in a little bit more pointed direction. So that was part one of our decision that led us here, is to take the three legs of the stool that were in Senate Bill 72 apart and focus here narrowly on the role of the judiciary and resolving that sort of jurisdictional mess and mess of roles and responsibilities that currently exist in statute, that it will exist no matter what. Like, if we take no action, that confusing mess of jurisdictional roles and responsibilities continues to exist unless we clean up the statute. And then we'll come back later tonight to talk a little bit more about the second leg, which is the provisional permit and change issue. But in terms of the draft legislation that we have come to an agreement on through the working group process, we tried to bring as much perspective as possible. And I can't remember if Rayleigh noted this. We actually had two models that we looked at. One model was an approach favored by some that would change the relevant statutes relating to roles and responsibilities to keep or to push all of these roles and responsibilities for resolving water disputes into the district courts. I think there's a common misconception that the do nothing option is that the district courts have the role and responsibility for doing all of this when the adjudication is complete. And as we did our research, that certainly is not the case. The statute is not clear in saying that once the water court in Bozeman, the adjudication court in Bozeman, completes its task, that everything just falls to the district court. That's not true. You still have that complex web of roles and responsibilities. So we explored sort of with the metrics that Rayleigh highlighted, a district court model that would change and revise statute to move the administration tasks and responsibilities of water rights to wholly into the district courts. That model did not receive a lot of support from the diverse groups of water users that were part of the working group. Instead, where we landed was utilizing, as Rayleigh said, those four water division and the water division court that already existed in statute. So currently in statute, as Rayleigh highlighted, there are those four water divisions that already exists. And as you'll see in this map, those pastel colors are the four divisions. Underneath them are the gray lines that represent the district court boundaries. And so you can see right from here some of the benefits of the division court model being one that reflects the hydrogeography of Montana, and that it's based on watershed boundaries rather than arbitrary political boundaries. So you have four water divisions: the Clark Fork, the Upper Missouri, the Lower Missouri, the Yellowstone. They're in statute today. Those water division judges exist today. They have some of that complex web of roles and responsibilities. The water division judges that exist today have some of those, but not all of them. And the water court, the adjudication court in Bozeman, ostensibly operates as water division judges as well, although maybe not as clearly highlighted. But currently, those water division judges are made up of sitting district court judges within the division that are selected amongst their peers, basically the short straw of who wants to be the water division judge within the division amongst sitting district court judges. And once we get into the next slide, I'll talk a little bit of why we didn't think that that model would work very well to keep it as is by relying on sitting district court judges to basically have a nighttime job, moonlighting as a second type of judge and having an additional workload. But this division that you see, the water divisions you see in front of you exist in statute today. Water division judges you see exist in statute today. So what we wanted to do was take advantage of that and build out and more clearly articulate what happens both today as we complete and hopefully as expeditiously as possible complete the adjudication, and then as we transition from adjudication into administration. So that's what this bill sought to do. And I'm going to just highlight on the next slide.
Can I jump in here, Clayton, real quick?
Please do.
Another data point that this group used was that this district court judges had been surveyed regarding their comfort with water law, probably 6-ish years ago. Another survey was done this past year, and that data was shared with us. And since the first survey to now, the most recent survey, district court judges kind of indicated that, one, they don't feel like they necessarily are as comfortable with water law as some of the other areas of law that they practice. And two, that many of them would prefer or indicated preference of water law cases going to someone with expertise or a specific court. So that also kind of helped us be informed on the direction that we're going to be proposing on the next slide.
Yeah, thanks. Thanks for highlighting that, Rayleigh. And certainly in my individual conversations with sitting district court judges, I think if you talk to district court judges, particularly in the faster growing districts in central and western Montana, they're also going to express a significant workload that those judges are already facing with criminal cases, civil cases, etc. So when you have a series of murder trials or child abuse or child neglect or partner family member assault, those cases understandably and necessarily take precedent. But as the population has increased, so has the workload of our current district court judges. And so in that survey, I think you saw that highlighted as well. Not only did very few people who have an expertise and knowledge in water law choose to run for district court judges because they don't have experience in criminal and civil and tort law. And the people who do have experience in criminal and civil tort law are the ones running for district court judges. So there's a workload issue, background expertise, and then just a sort of a timing. So excellent point. Here in the division court, I think I've done a pretty good job. I'm going to sort of bucket into 5 things. I think I've covered number 1, sort of what is the water division court. As I mentioned, it's not a new court. It's sort of an instrument that exists today, and particularly as you sort of weld the existing adjudication court in Bozeman, who is issuing decrees on the letterhead of water divisions, along with the existing division judges, you aren't necessarily creating a new court. And I think that's one concern that we had and we were aware of, is not expanding, creating a new court. That's why we wanted to utilize those existing water division judges. The one piece that we did feel was important in terms of what is the water division court, it's made up of judges and also an administrator that performs that sort of centralized data and record keeping task that is critically important, that has not necessarily been codified in statute, but certainly exists at the adjudication court, the water court in Bozeman, with a water court administrator there who make sure that the lights stay on, that the data is managed in an effective way so that you as a water user can call the water court and you know that all of the records associated with your water right as it has gone through that adjudication process are in a clear and organized manner. So what is the Water Division Court? It's made up of judges, at least 2 judges, up to 4 judges if the workload required it, to sit as water division judges in each of the divisions, as well as a water court administrator. I wanted to talk a little bit about how a judge becomes a judge. As I noted in current statute, those water division judges, and let me start with the water division judges in current statute. They are chosen amongst their peers as sitting district court judges within the division. For many of the same reasons we just highlighted in that survey, a lot of sitting district court judges don't have the time or expertise to be able to efficiently then do a second job, essentially, as a water division judge. So we wanted to resolve that to be able to provide expertise and timely resolution of disputes. And then you also have the adjudication judges, the water court judges, the chief water judge and the associate water judge, who are currently appointed by the Chief Justice of the Supreme Court, confirmed by the Senate. So as we imagined what the Water Division Court, with a strong role of both completing the adjudication and then having a clear defined lane to administer those decrees, how do you become a judge? And we, as I mentioned, at least 2 judges in each water in this is worded a little bit crazy, not very clear. There are at least 2 judges statewide. They were appointed by as a division judge in one of the 4 divisions, but certainly you are allowed to be a division judge in more than one division to try to deal with the workload. If there was a tremendous workload, as I imagine there's going to be in the very near future, you would have up to 4 judges, 1 judge per division. But at least as we start this process, the bill contemplates starting with at least 2 that could serve in multiple divisions. So you might be the judge for the upper and lower Missouri Basin, or you might be the judge for the Yellowstone and the upper Missouri. That is where we're at in terms of numbers. The appointment process, again, as I noted, the current sort of had 2 models. One is that became a water division judge by being a sitting district court judge within the water division. For a number of reasons, as we just enumerated, that didn't make a lot of sense to us. If our goal was timely, efficient decisions made with people with expertise in the area. So we wanted to go a different route. And there was disagreement amongst who should appoint the judge. And so we pioneered, and in the good old-fashioned way of compromising, we created a new system in which the Chief Justice of the Supreme Court would provide a list of at least 2, but no more than 4. So that means 3, probably, nominees to the governor. And then the governor is responsible for choosing one of those nominees to appoint as a water division judge. That's a bit of a compromise from the current system. And I think this is a piece that makes it uniquely different than Senate Bill 72 as well, that just had the gubernatorial appointments and then an election process. This bill does not contemplate an election process, but we were very intentional to make sure that there was adequate and ample opportunity for the public to weigh in the process of appointing judges, because we know and recognize that for all of us, these are our property rights. And so having an opportunity to weigh in the process was critically important. So to that end, we wanted to build in intentional public comment opportunities in the nomination process, which is a 30-day public comment period with the Chief Justice of the Supreme Court. with the 3 nominees that they decide to put forward, there has to be 30 days of public comment on those nominees. The comment has to attach to the packet of the nominee as it gets forwarded onto the governor, so the governor is able to review the public comment received for nominees. Certainly, the governor probably and could, if you wanted to, receive additional public comment if folks felt the need. It's pretty easy to call the governor, and I'm sure we have all called and left a message at the front desk with the governor's office. But that public comment period was really important. And then once the governor chooses somebody from that list submitted to him or her by the Chief Justice, that person has to sit for confirmation in front of the next Senate at the next general session of the legislature, which again is a robust opportunity for public comment and testimony on the judge who the governor has appointed. And we've all been around to see judges that have been nominated by these processes not get confirmed by the state Senate if folks are concerned. So, and certainly there's a fail-safe here. If the governor fails to appoint, then it goes back to the Chief Justice to appoint. But that's the process by which somebody becomes a judge. So, this is a bit of a compromise. It's also a unique place that I think is different than Senate Bill 72. In terms of the roles and responsibilities, sort of the work of the division court, a couple of things I want to highlight. Certainly, underneath the Water Division Court is continued to focus on primarily the adjudication and completing the adjudication that those judges are responsible for. And then the roles and responsibilities are expanded so that as we get to final decree, those judges are then responsible for, in a clear, defined, transparent way, for the administration and enforcement of those decrees going forward after final decree. That jurisdiction is important, and all elements, as I mentioned before, of water dispute are now clearly and explicitly placed in one venue or one place, one entity, so that if you have a dispute about your water right, you can go to one court, the Water Division Court, that in statute now has jurisdiction over all elements of that dispute. It also provides for the court, and the work of the court in adjudicating the water right is responsible for administering that water right after final decree is complete. I want to highlight one specific thing, and I'll come back to commissioners in a second. One thing that we certainly have heard loud and clear is making sure that there is a opportunity if and when, and certainly there are some cases in the state of Montana where a district court is uniquely situated and a district court judge is uniquely qualified and has been doing many elements around the administration of a water right and or the commissioner component. So we built in an explicit, and I think it's a much cleaner, explicit process by which you substitute, with good cause, you substitute and send your question back to your district court from the Water Division Court. So on all elements of this jurisdiction and the work of the division court, there is the opportunity for you to go back to your district court. And I would say the last piece of this is the piece around commissioners. And Rayleigh highlighted, and Senate Bill 72 sort of dealt with a lot of elements related to commissioners, including the day-to-day activities. And Rayleigh was accurate in that many of that, most, if not all of that discussion happened in the Water Policy Interim Committee. But the one piece that sort of had the nexus that was relevant to our discussion around the judiciary was, as I often call it, the tapping on the shoulder with the sword, the knighting of a commissioner who appoints the commissioner. And we believe that made most sense for the person who is the entity responsible for the administration of the water right should appoint the commissioner, and that being the division judge. Again, though, keeping in mind that substitution back to your district court opportunity that exists for all elements of the jurisdiction of the division court. So if you want your district court judge to appoint the commissioner in your case, you certainly have the opportunity in this bill through the substitution mechanism for good cause to substitute this back to your district court judge. The last piece I would just highlight here in terms of the other piece sorry, to go back to commissioners, I neglected to say one thing. The other thing we heard loud and clear from water users is that one piece that is broken today or not working as well as it could today, regardless of who chooses and appoints the commissioner, is that water users should have more say in who is going to be their water commissioner for the judge who is appointing them. And so the bill allows the petitioners the opportunity to recommend names of a commissioner that they have in mind to the judge who then appoints them, whether it be the division judge or if you substitute and go back to your district court judge, you have the opportunity to recommend a name of a commissioner or up to 3 names of potential commissioners that you would like to be considered by the judge. That's the change to the law that we heard from water users. And then last, and I think very importantly, because one of the frustrations with the adjudication court in Bozeman is, at least from a perception that, I know the Judge Mackley and Judge Brown are very diligent about getting out and doing elements of the adjudication work in the communities where they're basin that they're doing the decree in. And this certainly is not a knock on either of them, because I think they do a good job getting out and hearing matters in the area where the decree is happening and in the community that the decree is happening. But we wanted explicitly to make sure that there isn't sort of this central place where all of these decisions are getting made, potentially in a courtroom that is hundreds of miles away from you. And so explicitly venue, which is different than jurisdiction. Jurisdiction is sort of the authority, whereas venue is the place in which the dispute is heard, the building, for lack of a better term, the venue, that the dispute has to, or the controversy, the resolution, arguments around the controversy must be held and heard within the water division, and more specifically, or the county in which the controversy occurs. And I just noticed this in terms of the new section numbers here, that these are a little bit out of date, and I need to change those as we've done a lot of edits to clean up in the drafting process. Those section references of new section 12 and 10 are not accurate anymore. But
all right, should we pause here and take questions? Just a reminder, there are, please use the chat. We will look at that real quick. I know we saw one hand up, but would open it up for any questions that folks may have regarding what we've covered so far. Stan, I see that you have your hand raised. If you could, oh, looks like it's down. Okay, so no questions at this point. So let's continue on. Feel free to drop something in at any point in time.
Yes, of course. If you have questions, I one could talk about this for hours. So I covered it rather briefly. And Rayleigh might go to the next. Yeah, there you go. But 2, it's a lot to digest, and Rayleigh and I have spent 14 months now, almost 15 months, I think, working through all of this with a diverse group of sort of interest. And so what seems sort of common sense or commonplace to us might be something you really want to spend time or ask a question about, or you might be confused about. So as it marinates in your brain, feel free to type a question out. The second element, or the second bill topic that we worked on in this sort of final decree transition, as Rayleigh mentioned, we started last session with a bill, Senate Bill 72, that included both of these elements of issues related to the transition that we've covered today. The judiciary issue sort of roles and responsibilities of who's on first. And then it also included the reconciliation of provisional permits and changes. It was an intentional decision to break those apart so that we could have a more intentional conversation, both as a work group. And then I think we felt like we could have a more informed discussion with the legislature if we dealt with these two issues separately. So the judiciary.
So if you were familiar with Senate Bill 72, this would have been like sections 33 and 34, 32 and 33 of Senate Bill 72. So that is now removed and a standalone bill.
Yep. The notorious section 32 and 33. Rayleigh also did a great job of highlighting why this matters, or sort of what the issue is here, in that Montana made a smart decision. I think we would all agree back in 1973 in the Water Use Act and sort of subsequent attempts and the Adjudication Act of 79. Montana could have said, we need to complete the adjudication first and foremost before we ever contemplate issuing new permits for new water rights or changing any water rights. Like, we got to stop and press pause on everything to get a final quantification of what exists out there prior to July 1st, 1973. Montana did not make that decision and said, we can walk and chew gum at the same time. So we're going to go through the adjudication process. They also imagined it would take maybe 3 or 4 years to do that. It's taken 30 to 40 years to do that. But nonetheless, they thought they made the decision that we could complete the adjudication simultaneously issuing new permits and completing changes on both those new permits and existing water rights. That has meant, and through a number of legal challenges since then, that there has to be an opportunity at the end of the adjudication process to reconcile and make sure that those permits issued after 1973 are consistent and congruent with the final decrees, specifically related to the legal availability issue. So since a couple numbers here, since 1973, there have been almost 5,000 changes issued in basins prior to a final decree. And in some of those cases, those are going to be inconsistent with the adjudicated water right. For example, irrigator may have changed the point of diversion of their water right. And so when the water right abstract with the change is going to reflect a different point of diversion than the decreed water right, you've got to reconcile those. You could have made a change on a water right to change the place of use of which fields you were irrigating. That's going to be inconsistent with what the final decree says. You got to find a mechanism by which you can right size those. And in addition, there have been almost 12,000 permits issued since 1973 that are expressly, sort of per the CIADI decisions, expressly subject to that final decree. And if they are inconsistent with that final decree, specifically on the legal availability, basically the question of, had the final decree been available when this permit was issued, would the water that is issued in the permit have been legally available? You've got to sort of close the loop and reconcile that. But what we wanted, and I actually think this bill also has come light years from what was in section 32 and 33 in Senate Bill 72, and it really benefited from spending intentional time in this space, and I think the legislature will appreciate that too. But we wanted to provide a clear, transparent process to make sure that those changes and the provisional permits are consistent with the final decree. We wanted to provide certainty and finality. Like, we want to get through adjudication, through the reconciliation process, and have everybody with certificates of water rights in hand. Those are goals. And I would add another bullet that's not listed here. We also don't want to create another process in which you've got to hire a bunch of lawyers to defend your interests, whether you hold a new permit or your existing water right holder. We want to protect you. but we don't want folks to have a second bite at the apple because they lost that battle the first time. If you want to go to the next slide. I think the next one. Yes, this is, I think, the easiest way to understand. So I'm going to separate and just cover briefly provisional permits, and then we'll come to changes. And again, reminder that the provisional permits, so new water rights issued prior or post 1973, are subject to that final decree, specifically the legal availability analysis. And the question that is of interest, the focus of the reconciliation is, would that permit have been denied or modified had the final decree been available and the water was not legally there? So that's the only element of review, sort of the standard of review for the reconciliation process. But we want to make sure that there's adequate notice and opportunity. So right now, if a final decree is issued in a basin, let's just pick one, 41D, the big hole, since I'm right next to it. 41D, let's just say there's a final decree issued. There are a number of provisional permits in that basin. Within 60 days, there has to be a notice sent out. So DNRC is responsible for getting the information together of all the provisional permits in the basin that are affected with the final decree. They send out that notice within that 60-day period. That notice to all existing water right holders pre-1973, they now have the opportunity to prepare a petition, to hire an attorney if they needed to, or to petition the department, because in their analysis, that provisional permit would have been modified or denied had this final decree been available, because the final decree would have said that water was not legally available to the provisional permit holder. So there's a petition filed. It's got to be correct and complete. I'm sort of skipping over a couple of these because there's a little bit of internal administrative process just to make sure that you have a correct and complete petition. Let me highlight, actually, before I get there, highlight the petition, because here's that second bite of the apple that we were trying to protect against. The entities able to file that petition are existing water right holders. So those water right holders who hold a senior water right prior to 1973. You have to prove that change or modification or denial, revoking that provisional permit is necessary to protect the existing water rights of the petitioner, that petition would have been denied or modified had the final decree been available on the standard of legal availability. And you have to prove these things by a preponderance of the evidence. So you cannot petition because you don't like somebody, basically. There's a high bar, because in theory, there was a sort of complex and rigorous process that provisional permit 311 criteria went through, as well as the final decree. So we've had a very thorough analysis. This petition is really narrow in terms of what it can ask to be denied or modified. Then you'll see a response. There's an opportunity for the permittee to respond. The department makes a determination if they should revoke or modify. Then there's an opportunity for a show cause hearing to challenge the department's decision in the petition, sort of their resolution of the petition. You always then have the opportunity to file for relief in the court system. If the first bill passed, you file for that relief in the Water Division Court. But ultimately, then after that sort of remedy process, you get to a certificate of final certificate of water right. Another thing we heard in this process is that if there are no petitions filed, that we shouldn't monkey around and extend this process. We should get to that sort of certainty and finality quicker. And so if no petitions are filed, you do pass go and you go straight to certificate of water right. That's the permit piece. This one is a little bit easier. I can explain it and understand it. I'm going to give my best on the changes, because again, as I highlighted on changes, it's a little bit more, it's a little bit different. It's really those sort of scenarios that you're change may have been issued prior to a final decree, and now you have a final decree and a water right abstract that has been changed that are inconsistent. So what we wanted to do is provide within 360 days, again, you've had the change filed, the change approved. There's a final decree in your basin. Within 360 days, you have to certify that that change is in substantial accordance with the final decree. The DNRC has to go out and verify that with the two criteria being, is it in accordance with the terms of the application and accordance with the final decree? If it is, if that change, that water right is in accordance with number one and number two, yes, you get the final certificate of water right. If not, there's a show cause hearing for how you're going to remedy and get that situation back to satisfying 1 and 2 through a show cause hearing with the department. And that is provisional permit change and reconciliation. Again, I think that where we had the opportunity to spend some more time and drill down and look more intentionally at this, I think this is a better path forward than we had last time. I think both on the judiciary, it's an improved bill that's cleaner and more clear in terms of roles and responsibilities and articulating those roles and responsibilities. And I think we have adequately thought through sort of all of the boogeymen through the provisional permit and change reconciliation to make sure that we're not adding yet another process on existing water right holders who have been through a long and rigorous and very expensive adjudication process.
And a big thank you to Clayton, because he has done a lot of the heavy lifting as it relates to drafting and once compromise has been found, figuring out a way to put that into statute. With that, we can definitely open it up to questions. We're coming in on an hour here, but wanted to give anyone online the opportunity to ask any questions that they may have. We know that there's probably a lot of, I'll just say Senate Bill 72 is referred to a lot in conversations that I have. And so hopefully this provides you a little, a stronger understanding of how this approach is different and been pieced out to be more intentional and be more effective with the proposals that we are moving forward towards the legislative session. I'll give it a minute or two more for any questions, but just did want to, again, plug Clayton and all of the comp review members and say thank you to them for the work that they've been doing. I'll also plug that we have one more webinar scheduled November 21st, I believe it is, and that will be discussing the proposed exempt well legislation that the comp review is currently working on and finalizing drafts for. So I don't see any questions, so just want to thank everyone for joining us this evening. We will again be, this was recorded. We will be distributing it to folks. We will also be sharing the draft language of this bill, so that if you want to take a deep dive into that, you can take a look at that. Always feel free to reach out to myself or anyone at our office, and we can help clarify any questions. Or if you see Clayton while you're out and about as well, he is more than happy to answer questions as well. So again, thank you, Clayton, for joining us. Yep.
Right. I would just note on that drafting piece that certainly there's a version of the bill, both of these two bill drafts for the judiciary and provisional permits available on the comp review website, the water comp review website. There were a couple last minute cleanup items that we did at the October 10th comp review. So don't if you look at those versions that are posted on the website, there are some pieces that were discussed at the last comp review meeting that have not been incorporated. So we will get a final version and Rayleigh can circulate it to folks. But if you see something on the version that you can access on the comp review site, just know that it's a little bit out of date, as we've tweaked a few things, very minor things, but through the editing process.
All right. Thanks, Clayton. All right, and thank you guys all for joining us. We hope to see you in November for the exempt well conversation. And as always, feel free to reach out. Appreciate you and have a great night. Thanks.